When I first sit down with someone who's been charged with driving under the influence, I try to go over with them all of the possible defenses that Pennsylvania law recognizes. The first is whether there was a cause for the stop of your vehicle. For a police officer to pull anyone over, they need reasonable suspicion or need to have witnessed a violation of the motor vehicle code. The next defense that I review with my clients is whether, assuming that the stop was for good cause, whether the officer had any reason to suspect that you were under the influence, whether he made observations and recorded those observations in his police report that would lead him to believe that you had in fact been drinking. Assuming that the officer had reason to stop you and that there were signs of intoxication, you then have to review the evidence gathered in the way of field sobriety tests or chemical testing. Most of these issues that I've just described are what lawyers commonly refer to as suppression issues. So in other words, is there a reason to suppress for a court to not take into consideration all of the evidence gathered? It's really just testing whether the police officer violated any of your constitutional rights the night you were stopped.